Awesome. Thank you so much, Kathy. And thank you all for being patient with me. Tonight is a busy night. I've got 4 different engagements tonight, back to back to back. You are number 2, and every hour on the hour. So we're running. In fact, my 4th one is I'm getting in the car and actually going there physically. So the first 3 are via Zoom, and the 4th one is I'm showing up physically to make this thing happen. But listen, what I want to do tonight is we all know I recognize everybody here. We've talked about the foundation. I think we can kind of get past that anytime we have new folks joining us. I always want to make sure that foundationally they understand what we're talking about, purpose of government, purpose of the Constitution. But I want to address one thing. So much of the material that I bring to the table is stuff that I've created, right? Some specialty courses, but other stuff that I've created is curriculum that I used when I was teaching constitutional law at the college level. And just to give you an idea, teaching at the college level, that was about 48 hours of content that you'd roll through. And when you talk about the First Amendment, for example, we spent a total of 6 hours on that. And in the broad scheme of things, that's not a lot of time. 6 hours is not a lot of time when you consider that you could go to law school and you could spend several semesters just discussing the First Amendment, freedom of speech and the free exercise of religion and freedom of the press. But the collegiate level where I was teaching, we spent 6 hours on that. We spent about 6 hours on the Second Amendment. On the Fourth Amendment, which is what we started last week, we spent 9 hours on that. 9 hours on just the Fourth Amendment. Then we jumped in the Fifth and Sixth Amendment. We spend 5 to 6 hours on that. So the idea was not just to give individuals a general understanding of the Constitution, it was to give the individual a working knowledge. Now, I understand that everybody comes to the table with different expectations. Some have the expectation that you want to become an expert, right? And to become an expert means it's going through hypotheticals, and it's understanding as you go through hypotheticals, how do you apply the rule of law? How does the Constitution apply here? So there's a lot of hashing and rehashing to become an expert here. And I don't consider myself an expert. I'm a student continuing to learn along the way. But so that's one approach, which is, man, let's go through this stuff. Let's get down and dirty. Let's go through these hypotheticals, these different fact patterns, and really understand how the Constitution's applied. The other approach is, and I just want to have a general understanding of what this document's designed to do. I want a general understanding of what's found in the document and where to find it, right? And there's nothing wrong with either approach. Nothing wrong with either approach. So my plan today was to jump more into the Fourth Amendment, but I'm prepared to talk about anything within the document. In fact, one thing that we are going to dive into that we haven't touched on is the judicial system. How is that broken down? What does the Constitution say about it? How does the state judicial system interact with the federal judicial system? And what does the U.S. Constitution have to say about it? And I always love doing that because I'm able to give you working knowledge there as well, so that when you hear on the news or you read in the newspaper online that a particular case has gone to the Ninth Circuit Court of Appeals, or it's now going to the U.S. Supreme Court, you have a knowledge of where that case ultimately came from. What was the process to ultimately get there, which I think is very important, as opposed to, you talk to someone, you're like, oh yeah, the U.S. Supreme Court's deciding that case. Well, no, they're not just deciding the case. There's already been a lot of litigation. There's been hundreds of hours that have been attributed to this case, and here we find it at the U.S. Supreme Court as an appellate court making a particular decision. So let me open it up for a quick moment. I'd love to hear your perspective, especially as we continue on week after week. If we have a group where the general consensus is, hey, Shane, let's just give us a general working knowledge. We'll fly through this document. We'll hit on different topics, but it'll be, I don't want to call it superficial, but it'll be right hitting on certain points that I think are very important. Whereas a working knowledge is much, much different, right? Like I said, we're going to get down and dirty. We're going to hit a number of hypotheticals along the way. And for someone that doesn't want to really, for someone who's interested in general knowledge, man, going through these hypotheticals can seem rote. But for me, everybody comes at this from a different perspective. I want to defend this document at the highest of levels. And so learning how to do that's critically important. Let me open up you guys. What is your perspective on what you hope to take away from what it is that we do here week in and week out? Yes.
Both.
A little bit of both. I love it.
That's kind of actually what I was just thinking. I definitely want a working knowledge of it all, but I do want a little bit deeper than that too.
Yeah. So maybe a little bit of a mix with it, because I know sometimes when you dive in deep, you're like, man, your head starts to hurt a little bit, and you're like, man, is this what it takes? Yep, it's what it takes. But maybe kind of meeting in the middle there. Yeah. Anybody else? Brandon, what were your thoughts?
Oh yeah, I think I'm mostly here, I guess, just to generally learn. Especially, I like when we talk more about history and like what the founding fathers, or at least I like Shane's perspective of like when I've been reading a little more about history lately, but about how you see the founding fathers put these things in the Constitution and what you believe they were for. I was never a history major or anything, so this is all new to me. I have my own opinions, of course.
So you for you, Brandon, it's really diving in and kind of get just kind of a general perspective on what's happening.
I would say it's more general, but I love all the texts.
Okay, good deal. Anybody else want to chime in?
Yeah, I want as much knowledge as I can have because I'm fighting back against the broken system, and that's what I see is that our judicial system. A lot of it's broken. There's a two-tiered system, so I want to know what it actually says and how to fight back with our own Constitution.
Excellent, excellent, love it. Anybody else want to chime in?
Yeah, Shane.
On kind of your expectation.
Shane, this is Dave. Hey, I'm along for the ride here to learn, but I'm always fascinated by the decisions that our founding fathers made when we formed this country. So whenever we're talking about a law, if there could be maybe a reference to the Federalist Papers or our founding fathers and why they used the verbiage they did, that's stuff that I think is fascinating.
Awesome. I love it, Dave. Thank you so much for that. Appreciate that. Anybody else? Mike, it looks like you're ready to say something.
Actually, between tonight or, our Wednesdays and the Thursdays, I kind of feel like this is more the honor of God. Can you hear me okay?
Yeah.
Oh, okay. I thought somebody was saying they couldn't hear me. Anyhow, it's the knowledge is strengthening my resolve to not have to back down instead of saying, I don't know, and throwing something out there. So basically it's to learn more and learning more.
Yeah.
I want to be able to hold my own in a conversation, and use this as the armor to protect me in an argument if I have to have one before I finally walk away.
Yeah.
So, to me, this is about passion and love for the country.
Yeah, and I think with all that's going on culturally, it's more important now than ever, right? I mean, here we are holding the ideas to hold representatives accountable as citizens that are not involved as representatives, right? We're citizens. Our job is to hold down the fort, if you will. It's to hold individuals accountable. But you can't hold individuals accountable if you don't know what the document says and what they're supposed to be held accountable to. You can't defend liberties if you don't know what those liberties ultimately are. You can't defend rule of law if you don't know the rules that the government is supposed to abide by. So, that as we start on the Fourth Amendment, which, by the way, is one of my favorite. I love the Fourth Amendment because we deal with that almost every single day in some way, shape, or form. The government is interacting at a high level with regard to the Fourth Amendment every single day. I mean, just a police officer driving down the street, right? There are things that are going to happen, and that you can be assured, you can rest assured that every single day that officer is implicating the Fourth and Fifth Amendment every single day, multiple times. And so it's really important for us to understand those things. So anybody else want to chime in on that?
Yeah, I'll try.
All right, here's what we're going to do. We're going to dive in. Like I said, I was going to keep going with the Fourth Amendment, but listen, we can have fun coming back to stuff and kind of enhancing what we've talked about before. That's not a problem. But hey, Matt Chavez, I saw you raised your hand. What were you going to say?
Well, it's fascinating. I mean, just, obviously this is a huge learning curve for me. especially with the Constitution and everything, since it's always been something I've always been fascinated over, but never really took the time to learn. And just these past couple of years have just been awesome. But it's funny how, you know, you get into these conversations now with people, and kind of just going off what I heard, I kind of came in a little late, but you get in these conversations, and I think it's fascinating now. You just learning how to get people's perspective on how they feel and where they're coming from and what they know about the Constitution. And I think 90% of them don't really know anything. And I spoke to a lady today, and we had just gotten on a conversation, and she was talking about, you know, business owners and not allowing dissent, you know, the First Amendment and all this stuff. And I'm like, well, wait a minute. Whoa, slow down. Okay, so you're saying that since the business is keeping you, or your freedom of speech to say what you want to say and do certain things in that business, but yet that business isn't regulated by the government, and that business is not bound by the Constitution. It's a privately owned business. And she's like, whoa. And it was just like a total shift in her mind, not understanding that. And it was just fast. I was just like, wow. And then we had a great conversation after that. It was so cool.
Yeah, you know, Matt, and I've seen you do this a number of times, having just a general conversation and then bringing it back to this idea. Well, I just want to be left alone. Well, me too. I just want to be like, everybody agrees on that. And it's such a great conversation starter where there's no, there's no political obstacles that I have to overcome when I establish a foundation of, I just want to be left alone, because the other side believes that just the same. In fact, you know, I find myself in debates quite often with individuals on the other side on the pro-abortion versus pro-life issue. Both sides believe in this idea of being left alone, right? But it's different perspectives, isn't it? On the one hand, you have individuals that say, hey, it's my body, my choice. I just want to be left alone. And you have individuals on the other side say, yep, you're right. We just want to be left alone. But you can never be left alone and decide to use that choice as you go about wanting to be left alone to hurt somebody else, right? And so, but both perspectives start with a similar foundation. And of course, there are some issues where, man, are we going to make any progress? Well, we got to talk about what it means to be left alone. We got to talk about the role of government. What is their ultimate job? And we can start to make headway. But I love that as a group, we've discussed those foundational principles. It's not, oh, well, here's where I stand. Well, Trump, man, I can't believe what they did, man. They executed this warrant, and I'm mad as heck. And the other side's cheering the warrant on. And man, is there a way to establish common ground as we move into that conversation? Of course there is. So here's what I want to do. If you've got your Constitution,
it's always a good segue to the Fourth Amendment as well.
Yep, that's right. That's right. So, hey, let's do this. I'm going to share my screen. And if you've got your constitutions, I want you to open up to Article 3. Let's just hit on a basic structure of what Article 3 is designed to do. Of course, there are 7 articles in the Constitution, and there are 27 amendments. Article 1 speaks to the legislative branch. Article 2 speaks to the executive branch. Article 3 speaks to the judicial branch. So I'm going to share my screen, and we're going to go to Article 3. So I just pulled this up. So just a few sections in this. So let's take a look at this. And Article 3, Section 1. Notice that the words, there's some very important words here. The judicial power of the United States shall be what? Vested. Remember Article 1? It says all legislative power herein granted is vested in the legislative branch of government. Vested is a term of art. Vested means that which is given cannot be delegated away. So the only branch of government that has the ability to decide disputes, within that judicial realm is the judicial branch. Now, notice here, we've got 94 district courts throughout the country. If you're writing in your Constitution, you might want to write that down. You have 94 district courts and you have 14 circuit courts. So you'll notice here that there's only one court established in the U.S. Constitution. The only court established in the U.S. Constitution is the U.S. Supreme Court, right? It says, shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. What does that mean? That means that all of the district courts at the federal level and all of the circuit courts at the federal level have been established by Congress. So let's do this. If you guys have your Constitution, go to Article 1, Section 8. I want you to cross-reference this. And if you're noting something in Article 3, Section 1, I want you to just cross-reference that to Article 1, Section 8, right? That where it says, in such inferior courts as Congress may time to time ordain and establish. Where is the authority of the Congress to establish inferior courts? Well, it's found in Article 1, Section 8. So let's go over there real quick. Article 1, Section 8. And you'll see it. Let me see what that is. It's 1, 2, 3, 4, 5, 6, 7, 8. It's Clause 9. So Article 1, Section 8, Clause 9. And remember, Article 1, Section 8 is doing what? It's delineating the authority, the legislative authority of the legislative branch. In other words, it's telling the legislative branch what they are permitted to do. Again, another example of positive powers. The Constitution is one of positive powers. So what does it say? It says to constitute tribunals inferior to the Supreme Court. I love how this all comes together. It's pretty cool. Now, let me ask you this. Many of you know that the Ninth Circuit has a really interesting reputation, right? They are the most overturned appellate court out there. Now, I want you to think about this. Is there something that Congress could do to kind of rebuff what the Ninth Circuit is doing, other than just wait for their cases to go to the U.S. Supreme Court, only to have the U.S. Supreme Court overturn those decisions? I want you to think about that. We're going to come to that in just a moment. I want to hit on two more things before I turn that conversation back over to you. Look at the next line here. It says, the judges, both of the Supreme and inferior courts. What inferior courts are we talking about? The district courts and the circuit courts. I'm going to explain to you what a district court is and what a circuit court here is in just a moment. You're going to have a very clear understanding of what's going on. But it says those judges of the Supreme and inferior courts shall hold their offices during good behavior. Guys, this is, you now know more than 99% of the population, right? Because what do you often hear? Well, I want to put age limits on judges, or I want term limits on judges. Can we do that? Yes, we can, but it's going to take a constitutional amendment. Why? Why? Well, because the Constitution says subject to good behavior is the standard. Shall hold their offices during good behavior. Now, what's bad behavior? Well, there is precedent in terms of what bad behavior is and what that ultimately means. But here's the bad news. The bad news for purposes of individuals that would like to see a judge impeached, it's only had happened one time in the country's history. Only happened one time. It was Justice, I believe it was Chase, in 1806. So it's very difficult. How do you go about removing a judge? The same way that you would impeach a president, right? There's an indictment, if you will, or an impeachment that happens at the House, and then there has to be a conviction at the Senate level. It is very, very, very difficult, and it is certainly politically motivated. Certainly politically motivated, even if we don't want it to be that way. All right? So with that said, let me pull this up. I'm going to switch screens. Can you guys see that screen?
Yep.
Okay. Now what you'll see here is the way that the federal court system is set up. Now, remember, there is only one court established by the U.S. Constitution, and that is the U.S. Supreme Court. Now, look at this circuit court, and it says 13 circuits. There's actually 14. One is a bankruptcy court that's considered a circuit. So, and I'll explain that here in a moment. So going down here to the district court level. Now I'm gonna show you this, and then I'm gonna swing back over to the US Constitution and show you a few things. Does anybody know the difference between a district court, a court of appeal, also known as a circuit court, and the US Supreme Court? What kind of cases does a district court hear that might be different than the types of cases that a circuit court might hear? Does anybody know the difference here? Anybody want to take a shot at it? Okay. So a district court is a trial court. So I want you to think about the federal court actually mirrors the state court system. So I'm in Arizona, and in Arizona, you start at the Superior Court. The Arizona or the county Superior Court would be equivalent to the U.S. District Court. And then it goes up to the Arizona Court of Appeals, which is equivalent to the U.S. Court of Appeals. And then it goes up to the Arizona Supreme Court, which is equivalent to, at least to a degree, to the U.S. Supreme Court. Now, the U.S. District Court is a trial court, just like the Superior Court in Arizona or the Superior Court in Texas is a trial court. So let me just give you an example of how this would go down. Let's imagine that I'm a prosecutor and I'm handling a case at the federal court. Well, what kind of cases can be heard at the federal district level? Let's go down here. Let's take a look here. You see, this is Article 3, Section 2. It says this: the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, or which shall be made under their authority. So basically what it's outlining in this first paragraph is all of the kinds of cases that a federal court is permitted to hear, right? So you can go through that and you can see the types of cases. But what I want to go down to, you know, because it's kind of like looking at Article 1, Section 8. Article 1, Section 8 tells the legislative branch the types of cases they're permitted to hear, whereas we go here in Article 3, Section 2, and it tells the federal courts the specific types of cases that they're permitted to hear. But I want to go down here. You see right here, it says, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and facts. Okay, what does that mean? There's a difference between, and if you're jotting notes here, I want you to jot this down. The two types of cases that are being talked about here are cases where there is original jurisdiction and cases where there's appellate jurisdiction. As a general rule, the U.S. Supreme Court is a court of appellate jurisdiction. Trial courts, that is the district court, is generally a court of original jurisdiction. What does original jurisdiction mean? It means that's where the case begins. So you'll notice that for the most part, the U.S. Supreme Court is not where cases begin. It's a court where cases are appealed to. And this is going to make sense here in just a moment because I'm going to give you an example. So a trial court is generally a court where the case begins. It is a court of original jurisdiction. So as a prosecutor, and let's say that let's take Mike Slack. We're going to charge Mike Slack with bank robbery, right? He robs a bank, and so we charge him with the crime. Where is that case going to begin? Where's the trial court going? Where does that exist? And right here, the U.S. District Court. So what's going to happen at that district court is there's going to be an assessment as the law and the facts. So we're going to go into court, we're going to try Mike, and what is the jury going to hear about? They're going to hear about what law is being applied here and what are the facts of this particular case. So what's the law being applied? Well, the law being analyzed is whether or not Mike Slack met the requirements for bank robbery? Did his actions meet the requirement for the statute of bank robbery? Well, how are we going to go about deciding that? We are going to argue the facts. So the jury is going to be able to decide whether or not the facts in this particular case warrant a conviction under the bank robbery statute. Okay, so you've got that down. Now, what's going to happen if Mike is acquitted? Can we appeal that case up to the U.S. Court of Appeals? The answer is no. Once he is acquitted, the case is done. It's done. Prosecutors cannot appeal an acquittal. It's done, right? So the only time you're going to have an appeal is if there's a conviction. Again, I'm talking today, for purposes of today, we're just talking about what happens in a criminal case. So let's imagine Mike Slack is convicted. Is there going to be an appeal? Yes, every single time. In all of the cases for 14 years that I ever tried, there was never a case where we went to trial on that wasn't appealed up to the next level. Now, again, I was a prosecutor at the state level, so it went to the state court of appeals and then the state Supreme Court. There will always be an appeal. Again, for purposes of our example, Article 3 is talking about the federal judicial system. Now we're going to go up. Now, let me give you a real example of what this looks like. And I'm going to tell you about a case that I prosecuted years ago that went up all the way through the ranks. So it was kind of an interesting case. Let me stop sharing here so I can look at you. It was kind of an interesting case. It involved a stabbing, and it happened out here in Phoenix. And the defendant was kind of an interesting character. He was actually the barber for Larry Fitzgerald, the football player that played for the Arizona Cardinals for many, many years. He was the barber. And what happened was this guy came out here from Chicago. He settled down here, and he was dating the victim's ex-wife. And so they come, the defendant and his wife and his girlfriend come out here, and they bring one of the children out here that belongs to the defendant's girlfriend. And this is a child that is had between the victim and the ex-wife, right? They have that wife and child. They divorce, and the defendant and now his girlfriend come out here to Arizona, and they've got the child. Well, John Ulmer's his name. He is eventually the victim. He flies out here to Arizona to find out where his child is. Like, you had no permission to bring my child out here. Where you at? So long story short, the victim finds out where the defendant is living and approaches him at an apartment complex. And for those of you in Arizona, it happened over on 54th Street and Thomas. And they go toe to toe in a parking lot about 9 o'clock in the morning. And the defendant brings a knife out from his apartment and stabs the victim in the back. Now, here's what made it kind of interesting. While the stabbing is going on, the victim is on the phone with 911 as he's being stabbed, right? So he actually drops the phone during the altercation. He says, here he comes, he's coming at me. And he drops the phone, and 911, of course, picks it all up because it doesn't hang up, and they pick up the entire stabbing, okay? The victim actually lives, and he testifies in court. Now, what happens when we go to trial is it's a full-blown trial. We got a jury there, and we go into closing arguments, and the jury goes out to deliberate, and they come back, and it is a conviction. They convict him. Okay, so that is what happens at the trial level. Well, here's the issue, though. They actually appeal it up to the next level. I want you to imagine we're at the federal court level. Where would it go from there? It would go to the Ninth Circuit Court of Appeals. In our case, because it was a state case, it went to the Arizona Court of Appeals. Now, when you're talking about what happened at the trial level, what was the job of the jury? The job of the jury was to decide whether or not the government met their burden of proof. Did they prove their case beyond a reasonable doubt? They looked at the facts that were presented by the prosecution, They looked at the law that was to be applied. In this case, it was aggravated assault. And they made a determination that based on the facts presented by the government, that in fact, the defendant had committed the crime of aggravated assault. So the sentencing is anywhere from 5 to 15 years. I asked for the max. The defense asked for the minimum, and the judge splits the baby, for lack of a better term. They send him to prison for 7.5 years. But we're not done. We're not done, because the Court of Appeals is going to hear the legal issue. Now, understand, going back to the text of the Constitution, remember when it said that appellate jurisdiction versus original jurisdiction? Original jurisdiction means this: that court gets to decide not just the legal issues, it gets to decide the factual issues. When it goes up to an appellate court, the appeals court does not get to decide what actually happened. The jury already decided that. The only issue that appellate courts are deciding is the legal issue. Were the laws correctly applied? So in other words, they can look at a couple things. Was there misconduct by the government? In fact, here you got, guys, I'm going to be a little vulnerable here. This is kind of fun. They claimed that I engaged in prosecutorial misconduct, which quite frankly, when you appeal a case, it's not uncommon for the defense to say, well, the prosecutor or the law enforcement officer acted inappropriately. What would be an example of a law enforcement officer acting inappropriately? Well, he didn't read him Miranda. He didn't read him his Miranda rights, and the prosecution brought in his confession. And so on appeal, they would say something like this: that confession should have never been allowed because the law enforcement officer never read the defendant his Miranda warnings. And you might have a court say, you know what? That's exactly right. The law was not correctly applied. Therefore, we're sending it back down to the trial court for a brand new trial. Do you see what happened there? We're deciding the issue of law. We're not deciding factually whether or not the defendant committed the crime of aggravated assault. We're talking about how the law was applied in that particular trial. Now, what did they say with regard to Shane Krauser? They said that I engaged in prosecutorial misconduct because during the closing argument, are you ready for this? During the closing argument, I referred to the defense attorney as an octopus. This is a true story, guys. Shane Krauser, the prosecutor, engaged in misconduct because he referred to an officer of the court as an octopus. And so what did they do? They pulled the transcript, and the appellate court reviewed the transcript of my closing argument. And this was a very subtle thing. Did I mention the word octopus during closing argument? Yes, I did. Now, here's what you have to understand. When you're talking about closing argument, like there's Hollywood and then there's the real world. Hollywood and the real world, when it comes to closing argument, are kind of similar, right? You get down and dirty, like you're going for broke. People are playing for keeps, right? You've got government with their resources. They're coming in and they're playing hardball. And then you've got the defense doing the same thing. They're fighting to protect their client, and the government is doing what? Right? From our perspective, in this case, we're fighting to protect the community. It's a bad guy that did something really bad, and he should be held accountable. So I don't want to say all bets are off because you got to comply with the rules. But what did I say during that closing argument? I referred to the defense and I referred to his tactics of that of an octopus, to that of an octopus. And you might be thinking, well, okay, so you did refer to him as octopus. No, I didn't. And in fact, the appellate court in Arizona agreed. They said, no, the prosecutor came really close to the line, but he was referring to the tactic of the defense attorney as that of an octopus. And basically what I said was I got up during my rebuttal closing argument. And I said, ladies and gentlemen, for the last hour, here's what you saw the defense attorney doing. He was spewing ink. He was, I believe, trying to confuse you and take your eye off the real issue in this case. See, an octopus, when it's scared, what will it do? It'll spew ink, and it will spew ink to confuse the enemy. And that's what happened exactly as the defense attorney went through what he believes are the facts in this particular case. Let me tell you what the facts actually are. That was my argument. I was just saying, hey, it was obfuscating. He was trying to confuse. He wasn't dealing with the facts. Now, is that a legal issue? Yeah, right? Anytime you're talking about the conduct of government, that's a legal issue. Now, here's something else that was decided, was the jury instructions that were offered to the jury for purposes of deciding whether the defendant was guilty. And in this case, they decided that the judge did not give the appropriate jury instruction. They didn't give the appropriate jury instruction with regard to self-defense. So what does that mean? We're going back and I got to try that case all over again. It was the only case in my 14 years where I had to try the case twice. So it was sent back by that, remember that appellate court. All it's doing is deciding legal issues. It's appellate jurisdiction. It only decides legal issues. And they decided that the law was not correctly followed and applied. Therefore, guess what, guys, back down at the trial court level, you got to impanel a whole new jury and you're going to try that case all over again. That is not easy stuff, right? A trial in and of itself is very difficult. There's a lot of time that goes into trying a case. Now we got to do it all over again. And man, I kind of had a good time with it, even though it was a lot of work. The defendant did not like me, as you can probably imagine, did not like me. And so when I cross-examined him during the original trial, it was about a 6-hour cross-examination. During the retrial was a cross-examination that went on for 2 days. And that's kind of it, man. And you kind of get down and dirty in that cross-examination. But I just wanted to show you that example of how this works. So when you are reading in the newspaper or reading online, or you're at a gathering and they're saying that the Ninth Circuit Court of Appeals decided so-and-so, here's what you should understand. There was not a trial. The Ninth Circuit was analyzing the law as applied by a trial court. Same thing with the U.S. Supreme Court. The U.S. Supreme Court, as you probably noticed, doesn't hold trials. You don't have a prosecutor going in and a defense attorney and a defendant sitting at the table. There's none of that going on. All the U.S. Supreme Court is doing is deciding whether or not the law was correctly applied at the lower level. That's it. That's all they're deciding. So are there a few exceptions? Yes, but they're very, very few. Okay. So think about the Roe v. Wade case. When the Roe v. Wade case is decided, is the U.S. Supreme Court having witnesses called to the stand and all that? Nope, none of that is happening. All that's happening is you have lawyers from both sides making an argument to the 9 justices sitting on the court as to whether or not the lower courts got it right. So what we're seeing right now, let's just talk about something that's relevant right now. Donald Trump and the warrant. What's going to happen there? You're going to have a district court. A district court is going to make some findings as to the legitimacy of that warrant, if there's going to be a trial, all of that sort of stuff. And what do you think Trump's lawyers are going to do? Without question, they are going to appeal the application of the law at the trial court up to the next circuit court, and then potentially up to the U.S. Supreme Court. Does that make sense? Because where Trump is right now is he's dealing in a court, a trial court, that's dealing with both factual and legal issues. And as those legal issues are decided, there can be an emergency appeal, or there can be an appeal after the issue is decided altogether at the trial court up to the next level. So this is powerful, guys, to be able to understand what's going on. I'm telling you, if we sat 100 Americans on this call right now, I would be surprised if 99 out of 100 actually got it right in terms of the U.S. Supreme Court and the appellate courts and what their jobs are, right? This is important that you understand this. Now you're no longer kind of, just kind of flying by the seat of your pants. You actually now understand that when the appellate court or the U.S. Supreme Court is hearing an issue, they are not deciding the facts of a particular case. They're deciding the legal issues. So when you decide to get mad at the U.S. Supreme Court, like we do all the time, oh man, what are those guys doing, man? Like they decided the case wrong factually. They do not have jurisdiction to decide the facts of the case. There's only one court that has the jurisdiction to determine what actually happened factually. That is the trial court. The appellate courts, both the circuit courts and the U.S. Supreme Court, do not have that jurisdiction. They only have jurisdiction to apply the facts. So when this warrant issue goes up to the U.S. Supreme Court or to one of the appellate courts, they're just going to be deciding whether or not the government followed the rules when they put that warrant together and when they went about executing that warrant. That's all they're deciding for the most part. That will be some other issues, yes, but they certainly won't be factual issues. Okay, so we've got about 10 minutes left. Let me ask you this question here. Now that you know that the U.S. Supreme Court is the only court established by the Constitution and that inferior courts are established by Congress, this should get your mind spinning a little bit. It should really get your mind spinning in terms of what power Congress has in dealing with inferior courts. So let's say that you have an appellate court, and that appellate court, like the Ninth Circuit, generally speaking, is a train wreck. In fact, I remember going to law school, and there were 32 cases that went from the Ninth Circuit up to the U.S. Supreme Court, and 29 of the 32 were reversed. They were reversed outright. In other words, the U.S. Supreme Court was constantly reprimanding the Ninth Circuit, saying, do not create your own law. The precedent is established by the U.S. Supreme Court. You must apply precedent. And the Ninth Circuit was basically flipping their finger at the U.S. Supreme Court and saying, yeah, we don't like what you've said, so we're going to go ahead and do what we want to do. And then it would go to the U.S. Supreme Court and they'd slap them again. Like it was kind of like a dog coming in, and the dog would urinate on the floor, and the U.S. Supreme Court would take their newspaper and smack him over the nose and say, don't do that anymore, right? So I want you to think about this in light of the conversations we've been having for the last several months. What can Congress do to rein in a runaway Ninth Circuit, for example? What can they do? Any thoughts on this?
Shane, if Article 1, Section 8 says they can establish them, or they have jurisdiction to create them, can they disestablish them?
What do you think, Dave?
Yes.
Seems to be what it says.
That's what it seems to say. Absolutely. Thank you, Dave. I'm coming back to you. Any other thoughts on this? Any other thoughts on what the court can do or what the Congress?
I don't know what they call it, but I mean, can they be censored? Yeah, can they censor the court? Basically penalize them.
Yeah, so there's an impeachment process that can go through, but you and I know, as we discussed earlier, that's very, very difficult. But what can happen? So aside from impeachment, where you can reprimand judgments, like I said, it's very difficult. What can happen is, just as David said, if they can establish them, they can disestablish them. Now, I want you to think about this. That literally Congress could get rid of the Ninth Circuit Court of Appeals. They literally could get rid of them, and they could realign the various circuit courts. I mean, listen, you got generally 13 circuits, but they got that 14th circuit that's kind of a specialty. But you've got that they could say, you know what, we're going to get rid of 5 of the circuits, and we're only going to have 8 circuit courts now. Like if you could have I don't want to call it a rogue Congress because they have the authority to do that. It's not outside the scope of their authority. But I want you to think about this in terms of changing the dynamic of the political discussion going on in America. Remember, we talk a lot about town halls, and going into a town hall and asking someone who's running for Congress what they intend to do about a Ninth Circuit. That is a very popular issue out here in Arizona, because the Ninth Circuit, right, oversees what's going on at the federal level in the state of Arizona. So think about a question that could be asked of someone that's running for Congress. Hey, you're running for one of the most powerful offices in the country as a legislator. We know that the Ninth Circuit has done things to not only defy the Constitution, but to defy precedent established by the U.S. Supreme Court. As a member of Congress, what can you do and what will you do with regard to the Ninth Circuit Court of Appeals? Guys, think about that question. We need individuals in Congress that understand that they play a huge role when it comes to the federal courts. It's not just, oh, the federal courts, they said it, so we'll just lie back and do nothing about it. Congress has incredible power to deal with these various circuit courts. And I went out to, this was several years ago. I went out, I testified in front of Congress, and there was a time that I was there where I was working with all of the incoming freshmen. So they've just been elected. And guys, you want to talk about fun times? It was a lot of fun, but it was sad too. Most of these incoming freshmen had no clue. They had no clue the power that they ultimately had. Why? Why did they have no clue? Well, because they weren't voted in based on their knowledge of the Constitution. They were voted in based on their ability to shake hands and kiss babies, right? They went to all of these town halls and they were super nice. They combed their hair just right. They were just pleasant people. And based on that criteria, they were voted in. So now here they come rolling into Congress. And I was, there were times where I had several days where I was able to work with them and talk with them about the parameters of the Constitution. This particular issue came up. And when I talk about having 100 people on this Zoom call and most Americans not knowing this, listen, it was bad. It was bad. Members of Congress had no idea that they had the ability to check the various circuit courts, which is an incredible power, right? Now, can they mess with the U.S. Supreme Court? It's the only court that they can't dismantle. But what can they do? Well, you can say, hey, we no longer need 9 justices. We're going to go with 5. Or we don't want just 9 justices. We want 15. So you've heard Biden talk about packing the courts. Here's what I want you to understand. When a president starts talking about packing the courts, there's nothing necessarily unconstitutional about it. It just has to go through the route of Congress, because Congress gets to make those decisions. 9 has been the rule for decades and decades, right? But can they pack the courts? Yeah, they could do it, and there would be a fight. Would that happen under the current numbers? It's just not going to happen. Under the current numbers, the chances of the courts being packed are next to impossible. But could it happen? Yes, it could happen. And, but again, it's got to go through Congress. Congress that has to make those decisions. So, guys, our time is about up. But here's your assignment. I'm going to put something down here that I think you'll have a lot of fun with. Actually, let me share my screen again as we close out here. Let's go up to. Can you guys see that? Where it says U.S. Supreme Court? Are we on the right screen?
Yep.
Okay. So here's what I would recommend, guys. You want to have some fun. I want you to go to this site. Oh, yay. Let's see if this is the right one. Okay. OEA.org. OYEZ.org. Guys, go spend some time on this site. Here's the cool thing about this. If you want to go in and you want to listen to oral arguments, you can listen to oral arguments from any case over the last 40 or 50 years. If you want to go in and listen to the Dobbs v. Jackson oral argument that overturned Roe v. Wade, you can actually go in, pull up the case, and you can actually listen to the oral arguments that happen in the U.S. Supreme Court. It's pretty cool. This is a great resource because it allows you to listen to arguments, but it allows you to also to access the briefs put together by both sides. And I'm telling you, if you haven't been in the U.S. Supreme Court, it's something, man, I encourage you. It's quite an experience. I've been out there a couple of times. I was actually involved in taking a case to the U.S. Supreme Court back in 2000. I think you remember me talking about this. I was involved with with a group of attorneys that attempted to overturn Miranda v. Arizona. We attempted to overturn the Miranda requirements as not being required by the Constitution. Good policy, but not required by the Constitution. And man, it was exhilarating. It's an exhilarating experience. You got people packed in, the general public are allowed to come in. Then you got the 9 justices walk in, and you got the 2 attorneys battling it out. Each side's given 30 minutes to battle it out and talk about what they believe the court should ultimately do, subject to questions, and you can actually go on and listen to those things. So with that, guys, if you have ideas about what you'd like to talk about, we'll take on any topic. We'll stick to the Constitution, and we'll talk about how these principles are actually applied day to day. So with that said, guys, it's just a pleasure to be with you. Apologize, time is a little bit short. I got another engagement starting right now. So Kathy, thanks so much for having me. Thanks for being patient with me as we got started a little bit late, but it's a pleasure to be with you. Kathy, you're on mute.
Yeah, how do you do that? Okay, thank you. I appreciate you being with us tonight. I think definitely we have some questions and things going on in the chat about court. So I think maybe next week we want to kind of address some of those. I know I want to talk about fully informed juries and some of the things I've seen happening in courts that I don't understand. About
Kathy, what did you say?
law and different things like that, so.
Kathy, what were you saying? Did you say hung juries? What were you saying?
No, fully informed juries.
Oh,
I mean,
yeah.
I've been a witness in a trial while juries are sent out and excluded where they don't even see a lot of evidence. So I kind of want to understand more of those things that happen in the court. I know people want to talk about admiralty courts. We know the courts that have the gold fringe and those that don't and stuff like that. So maybe we can continue on with this next week. It'd be awesome. Learn more about the courts. Thank you guys for being here. Appreciate your time, Shane. Was there anyone who'd like to volunteer to give a closing prayer for us as we depart? If not, then I will be happy to go ahead and do that. Our Father in heaven, thank you for this day. Thank you that our technology worked well today and that we could learn more. We ask you to bless us as we go throughout this week, that we will have opportunities to stand for liberty, to use and increase our knowledge in doing so. And give us a gift of safety and peace. And the things we pray in the name of Jesus Christ. Amen. Awesome. Thank you all. We'll see you next week.
Amen.
Thank you.
Have a good night.
Yeah, have a good night too. I know this just brings up more questions. We want more court stuff. I definitely want to hear about the differences in admiralty courts. I think some of us have, because Shana Cox taught us a little bit on it. I definitely want to hear Shane's perspectives on it. I want to hear more about fully informed juries and stuff like that. And so.
Yeah, I think Jeremy was bringing it up in chat about like the gold fringe on the flags and everything, and like how the courts yeah, all that stuff is interesting. I wonder what Shane thinks about all that.
I know, yeah, and I know he's in so much of a rush. There's no time to really. It wasn't as much just chatting tonight as usual, which is cool because we got a lot of information, but now we have questions. So
yeah, that was mind-blowing. That was a lot of stuff to run through for sure.
Thank you so much, you guys.
Say that again, Christy.
I said thank you so much. Are we going to do this again next week?
We are going to do it again next week.
Thank you so much.
Yeah. Did you join us from the People's Rights text or?
Yes, ma'am. The People's Rights text.
Awesome. Yeah, we will send one out again next week, and absolutely, we will do it again next Wednesday.
Thank you so much. It's been so informative.
Yeah, it is really great. We are learning a lot, and sometimes we go real deep into subjects. And tonight we started out talking about how do we want to go a little faster to cover more territory, because some people want to do that. Some people want to go really deep. So one of the things I want to talk about, I've been witness to a trial. I had a friend whose daughter was put on trial for murder. And it was a really interesting situation. I believe that her boyfriend, or her husband at the time, did have something to do with the murder. She tried to hide him, so she maybe was an accessory after the fact type thing. But what was interesting was that the jury was sent out time and time again, and the whole trial was like a little play. They would send the jury out of the room, and then they would instruct the witnesses of what they were or were not allowed to say. And as just a spectator in the courtroom, I heard so much more testimony than the jury ever heard. And what I heard would have absolutely made me acquit that person, because I did not see evidence that convinced me of her guilt beyond a shadow of a doubt or beyond a reasonable doubt. But the jury, who didn't get to hear, a fourth of the evidence that as a spectator I got to hear, they come in and they convict her. And she's out of jail now. On the appeals process, they struck up a deal with her and everything, because it was overturned. And then they scared her and they said, well, if you don't plead guilty, then you're probably going to get this many years. And she had a child at home. So she ended up taking the appeal, and they gave her like another year and a half, and she ended up getting out. So, but it just, I wonder what about this process of sending the jury out and not letting them hear exactly what's going on, about why juries can't be fully informed and why they're told you only have to consider what we tell you to consider. You can't consider other knowledge that's come out in court, or, I just want to consider some of these things, because I think maybe these are modern concepts that are not in the Constitution,
Huh.
Yeah,
I haven't sat in a trial like that or anything. So that I think that is interesting. I wonder why they would withhold info. That seems silly. That's like not justice to not give someone all the facts, or at least as much as you can give.
It was really interesting, Brandon, because during the trial, they had a man come in who had been in jail, and they did a plea bargain with somebody else who was in jail. And they said, if you can turn in 10 people on this, we're gonna let you free on this other minor charge. But you have to turn in 10 criminals, just random criminals. And so of the 10 people who turned in, one of them turned out to be this other young man, not the one who was accused of murder, but the other young man who testified in court. And he said the other young man bragged to him that he had something to do with this murder. Well, they were in jail together. It was just a roommate situation in jail. And he just snitched on him. So then that young man came to court, and before I even heard the testimony from the other man, because that was from a neighboring county, I knew that that young man had something to do with the murder. His demeanor in court was powerful. He was shaking and just listening to his testimony, I'm like, he's not the one on trial, but he had something to do with that murder, and I knew it. And then sure enough, like 4 days later, then this witness comes in from another county and says, one of the things that had been admitted to their county was that this man confessed to murder. So, but the jury wasn't allowed to hear any of it. They sent him out.
What the heck?
And then they discredited the information, saying, well, a snitch told it, so it's not good information.
Oh my gosh.
So I just wonder, why are juries not fully informed?
It's because our justice system sucks.
All the facts. And informed of their rights, because a lot of juries don't know that you can actually find out innocent even if you believe that they did it, because you believe they're justified. I think that's something to do with being fully informed. I don't know, maybe somebody knows more about fully informed juries.
Well, yeah, that's everything, right? Is that if something appears to be justified, at least like legally or lawfully, like just in like any killing, like I don't want to really call it murder, but it's like if the only facts you have is that some guy shot another guy with a gun, it's like, yeah, then I guess you're gonna throw the killer in jail. But like, what if you find out that the guy who did the killing was trying to protect somebody else, or yeah, exactly. All that info needs to be thrown in there, because otherwise you just look at the straight facts and you're like, yep, he's guilty because he killed someone, like without knowing, oh, he was defending an innocent person. Like all that crap needs to be in there.
Yeah, like Jeremy just said, Lavoy Finnegan.
I've never heard of that. What is Lavoy Finnegan?
Lavoy Finnegan was one of the associates of Ammon Bundy of the Bundy family, who had quite a little battle with the BLM, Bureau of Land Management, over land rights in Nevada and Oregon, Idaho, that area. And LaVoy Finnegan was a sheriff in Oregon wanted to arrest him, and they were trying to leave and go to another county where there was a safe sheriff. They knew that this sheriff was totally against him. And so they were driving on snowy roads with the sheriff around them. And they kept telling them, we're going to turn ourselves into this sheriff. And you can find a video for this on YouTube. And LaVoy Finnegan was shut down. Shauna Cox was in the car with him, was shot down in cold-blooded murder. He got out of the truck, was standing with his arms above his head.
Wow.
When he was shot down, we all witnessed it. It's on TV. You can watch the YouTube videos of it. It was a flat out an execution. An execution, and no doubt about it. And you can look up LaVoy Finnegan. His daughter was going to speak to us. I've heard her speak at People's Right for Arizona before. And she was going to speak to us, and she had a personal crisis go on in her family that night, and she couldn't. So,
That's nasty. Wow.
And see if we can get her again. Because these are people like Ammon and Shauna Cox, and LaVoy Finnegan. There's a lot of people who've had some firsthand experience with the misworkings of justice, misworking for sure. But yeah, if you haven't seen LaVoy, look him up on YouTube to hear his story, because it's pretty dramatic. Yeah.
Yeah, I'll definitely give it a look. Thanks.
Yeah, you bet. All right. Well, I guess we'll go on out of here and see you guys next week. I think people should, whatever you want to speak about, don't hesitate to bring it up. I always worry a little bit, oh my goodness, offend somebody or think I'm not interested in what this is. But I think that Shane is willing to be guided and give us the knowledge that we want. So I think we just have to and let him know, and he'll be willing to curve it in that direction. So
yeah, we gotta ask him. We gotta make sure one of us asks him about the admiralty law thing.
Yeah, I would like a greater understanding of that for sure myself.
Yeah,
and
what he says, yeah.
And we were talking earlier before the start about the whole thing with the real ID and all this kind of stuff. I kind of find myself getting more and more of the feeling of I don't even need a stupid driver's license. The Constitution gives me the right to travel. I just don't like the government overseeing and controlling every little action. Everything they do is to get power and control and money.
Yeah.
And I'm kind of burned out on that,
I totally agree. I totally agree. No permits required for any of this crap. This is freaking silly.
Right. Yeah, I need a permit to build a doghouse now. It's just ridiculous.
Yeah, so you need a permit to build a fence in your own property that you own. It's like, what? It's like, what happened to it's literally the Fourth Amendment, right? Like, you have the right to your own to privacy, to do what you want with your land.
That's right. What do you need building permits for? It's all about controlling money. It's all about controlling money. So.
Yeah. Or is it maybe it's the Fifth Amendment? No, I get it all mixed up. But where the government, shall not take something that's private and make it public. That's effectively what they're doing.
Yeah.
I hate it. But yeah, anyway, call it a night. Just got to make sure we know Shane about the Admiralty thing. That sounds really cool. Good chatting with y'all. Take care.
Yeah, you too. Good night, all.
Take care. Love you all.
See you next week. Yep, love y'all too. Good night.